from the law firm? No. Don't want to share? Okay, that's fine.
So let me just touch on one point real quick. We mentioned kind of gamification a little bit. So there's a lot of different aspects to gamification. And again, for the most part, you know, if you're dealing with points and you know, kind of any kind of virtual currency as a part of gamification, obviously there's a host of issues which we'll cover in one of the later parts of this series. Most of the other issues are fairly straightforward, but there's one that some people are not aware of, and a number of companies have kind of done things which, again, seems like a good idea from a business perspective, but not so much from a legal perspective, and that is incenting users, right? So the whole aspect of gamification, you know, in general is to use different forms of game mechanics that essentially to incent users to take actions you want them to take, right? Very, you know, basic definition. And you can do it through leaderboards, points, badges, rewards, and all the other types of things that are involved in gamification. But when you incent users to take certain actions, for example, endorsements, and endorsements is defined very broadly by the FTC. You have to make disclosures. And so what's typically happened, and the FTC has published what's called the FTC endorsement guidelines. Initially this came about because there were a number of bloggers, paid bloggers, who were writing product reviews which appeared to be unbiased reviews, but yet they were actually paid for. People got free products and were obviously writing favorable reviews, not because that's what they truly believe, but because of the compensation that they were getting. But when the FTC issued their endorsement guidelines, it actually went much broader than blogging, and it really covers any online activity. And they even give examples that if you reward people with points or virtual currency for writing positive reviews, you have to disclose this to the affiliation. There's been, you know, a lot of people don't comply with this, I'll tell you that right now. You know, if you're, you know, giving some nominal amount to a user for just writing a review, people do that all the time and don't comply. But where you will get into trouble, and where most of the fines have been issued in this case, is, for example, when employees do it, right? Either positive reviews about your products or negative reviews about your competitors' products. When you are affiliated with the company, or there's been situations where some ad agencies have actually written reviews or paid people to write reviews or do, you know, endorsements as part of that was just part of the marketing campaign. And there's been several fines in the six figures kind of dealing with this. So. You know, just at a high level, just be aware that exists.
Which party needs to make the disclosure here?
So it's the entity on whose behalf the endorsement is being made actually has an obligation to ensure that the person doing the endorsement discloses whatever the affiliation is.
In the endorsement, presumably.
Yeah, and it could be very simple, you know, a very simple notice. But you know, there's a lot of people, a lot of platforms that have, you know, as part of a user referral mechanism, it's like, you know, refer a friend and get you know, some reward. If it's just a referral, that kind of is arguably not within it. But if you're writing a positive review or doing something that constitutes an endorsement, which is defined pretty broadly, and there's a disclosure and there's some compensation, you need to do a disclosure. And so I'm going through some of these slides kind of quickly. Anyone wants this presentation, I'm not going to go through all these in detail tonight just so we can cover some more topics, but happy to send this to you if you shoot me an email. Another question?
So would that include anything of material value, including like virtual content?
Yes. In fact, they have specific examples at the end of their guidelines that specifically says yes to that.
So if I incentivize my users to write a review in the App Store, that would be considered?
Yes. Not everyone complies with that. You know, and then that's the other thing too. So I was talking to someone before, you know, about, they were asking about the, and we're going to cover this in the next section in more detail, but you know, the enforcements in Japan under the Gacha game mechanic. There were 4 very large Japanese companies that were using the same mechanic, making a lot of money. And what's interesting is that, you know, many times, and Justin, tell me how many times you've heard this, when a company comes to us and says, you know, here's what we want to do, and we tell them what some of the legal issues are, like, yeah, but so-and-so is doing that. Why can't we do it? Just because so-and-so is doing it doesn't mean it's legal. The fact that they haven't had a regulatory enforcement yet doesn't mean they're not going to get one. And the question, again, from the business risk perspective is, do you want to be in the same boat with them? So when the enforcement went down in Japan on that, all 4 of the major companies that were doing it went down at once, and if, public companies down 20% in a day because of that. That's not the kind of thing that you can have any solace that your competitor is doing it. Yet we see all the time that when it's a very profitable mechanic, people don't want to be left behind, and that kind of creates again that tension between the business opportunity and the legal risk. So it's fun while it lasts. But so real quick, I want to get into the IP stuff. I know that there's a lot of interest. People who talked earlier about IP protection beyond the copyright we talked about. But just real quick, I want to just mention a couple things. The FTC, while they've been very active in enforcement, they're not the only federal agency that's dealing with these issues. The FCC and even the FDA, if you have mobile medical app or wellness-related apps, they're getting into the game as well. There's a number of things, like even under the Telephone Consumer Protection Act, with the FTC governed. Originally, it was directed to the do not call type features. They've interpreted SMS text to be covered by the TCPA. So there's limitations on what you can do even through text under things like that. On mobile medical apps and games, what's interesting is that this is multi-jurisdictional. You would think that this is primarily an FDA type of thing, and the FDA has issued guidelines on mobile medical application. They've issued guidelines that define what is within the scope of what they're going to regulate and what you're going to do and what you can do, what you can't do. And you see here just an overview of some of the issues. And they've actually jointly issued guidance with the FCC to regulate various forms of mobile health related applications. So if anyone is doing stuff specific to that genre, just be aware that that's another set of issues. So let's talk about IP protection. So we talked a little bit about copyright earlier. Chris, I was talking earlier with you, and it's again, given Chris's background in New Zealand and London and the US, you've kind of dealt with different types of IP issues and schemes in different countries. As a developer, what are your thoughts as a from IP protection strategy? How do you think about IP as a business person?
So I guess the two that we deal with most commonly are trademarks. So we have half a dozen trademarks, mainly in the US, and patents. So we have one US patent that's been approved and two more pending. Personally, I like patents because it's a very long-term way of looking at your business. So unlike a product roadmap, which might be 18 months, a patent is more kind of what you want to do in 4 years' time. We do it mainly for protection, because an MMO takes about 3 years on average to build. And we had one technical difference that we saw as a market differentiator, and we wanted to make sure after that 3 years we weren't going to get a patent suit slammed on our table. So it was a relatively cheap form of protection, but also an opportunity to carve out a niche for ourselves moving forward.
So you view it more defensively
yes,
as opposed to offensively?
Definitely. Yeah.
So it's interesting that the laws in the U.S. were changed last year, and in the U.S. there used to be what's called the first to invent patent system, and now we went to first to file. And so what that means is that in the past, if you were working on a game for 3 years, if you didn't publish it and the information remained secret, if someone else filed a patent application and you can actually show that you invented it earlier, you may not have liability for patent infringement. And if you filed your own patent and you could establish an earlier date of invention, even if they filed before you could still get the patent. No longer. Now it's whoever gets to the patent office first wins if there's competing applications. So one of the things that we're seeing as a result of this is that we're seeing two things. One is, in general, we're seeing more patents in this space and more patent filings, in part because I think people are starting to realize that there's been more and more patent enforcement in this space, and as a minimum, from a defensive perspective, by filing patents, you prevent others from patenting what you're doing. And that value alone can be very significant, particularly given this change in the law to first to file. So we're seeing a lot more companies filing at an early stage. And one of the questions we always get is, when should we file a patent? Right? When we first have the idea, we're ready to launch the game. The answer is that it depends. You don't have to have built something to patent it. if you have a pretty clear vision of the functionality of what you want to do for your MMO or your game or your mobile app, as long as you can clearly articulate kind of that overall functionality, that's generally the level of disclosure that you need for a patent. So our general advice is consult with a patent attorney or IP attorney relatively early to understand a couple of things. One is, do you have something that's protectable? And the second is, there are some timing issues with respect to patentability. Clearly, if someone files before you, then you're going to lose out on your right. But even your own activities, if you disclose your idea before you file it, there's certain clocks that start ticking. And so understanding whether or not you have a clock ticking against you, it's good to at least understand that. It doesn't mean that you necessarily will have to file right away. You may want to still wait. But what you don't want to do is wait and then go to an attorney and understand that you lost out because you waited too long and you didn't get a chance to make a business decision. It was kind of made for you. So from a patent perspective, we're seeing a lot more activity in this space, and we encourage people to at least assess whether what you have is protectable or not.
So question for you. So with an MMO, right, it takes there's a long time to make it. I think that might be a different case. But for mobile games in general, what are some of the types of things that maybe you've filed already and can talk about, just to give folks here a sense of, for mobile game developers, what are things that they might consider patented?
Yeah, so I mean, as this slide kind of indicated at a high level, I mean, you can patent, in the U.S., the law is much more permissive in the U.S. than in the rest of the world.
Sorry, I can't see behind you.
Okay,
You had it up there.
Yeah, so in the U.S., you can protect the functionality. So what is the, kind of the user experience? What are the interaction? What does the user do? You can protect the methodologies and processes if you have ways of implementing things in your games. Different game mechanics, those are all protectable, and even business models, right? So to the extent that you have very, different iterations on how you are monetizing your game, you can file patents and get that in the U.S. There's a lot of confusion about that. There's a lot of people believe you can't get patents on business method. The Supreme Court has said there's no prohibition on business method patents. They have to meet all the requirements of patentability, just like any other software patent. But we do a lot of work in that space. We're getting a lot of patents issued, as others are.
Successful business model in games that maybe you guys have patented? Because I see that line and I get a little confused, because I think business model is subscription, freemium. How can that be patented?
Right. So there have been ways on how to different aspects of virtual currency systems, for example. And again, like, what's patentable now, because there's so much of this is out there, right? If you tried to file a patent today, you might not get it. But like Zynga, for example, recently got one on a dual currency system where it was to deal with the Zynga poker, where you had one currency that you use for gambling and one for not. Now there's more to it than that. That's a gross generalization of it. But it was a way to implement that model around the virtual currencies so that you could comply with the laws, and they have a patent that I think I recently saw it was allowed. I don't know if it's been issued yet, but it's been approved. One other issue that comes up with patents quite frequently, and I was talking to Chris about this earlier, how they deal with this is the timing. His project is a kind of a longer-term project, and so getting a patent quickly may not be that big a deal. For others, getting a patent quickly may be more important. And one of the things we hear, when we talk to companies and companies are deciding whether to file patents, there's often a mix within the company. There's one person that doesn't like patents, doesn't want to file it, doesn't want to waste money. Someone else, like, we have the patent we have, it's a distinguishing feature. There's usually some internal tension. And one of the arguments that we always hear is, by the time you get a patent, it'll be 3 years, and this game or this app will be either successful or it's not, and we'll be on to the next thing. And it's a valid consideration, but a couple of points of clarification. One is, if you, like Chris mentioned, if you have a mechanic or some technical feature that you think is different than what others are doing, and you patent that, more likely you're going to build on that, not remove it. So as you iterate your game or your mobile app, you're at least for that genre, you're going to continue to use that, and you get protection under patent for 20 years from the date you file. So if you have something that's significant and you're successful and others want to copy, there can be significant value in that patent. The second thing is from a timing perspective. It is true that if you file a patent in general in the U.S., it can take 18 months to 2 years just to get a first response from the patent office. And that may or may not be acceptable or sufficient, you know, if you have an app that's out there and people start copying you right away. There is a new procedure as part of the law that was passed, or that was implemented last year. There's a new procedure called Track 1. And what that procedure is that if you're a small company, under 500 employees, it costs you an extra $2,400 when you file the application to request Track 1. And you can get your patent examined. They don't give you a specific time frame, but we've done this with a number of clients. We've gotten patents allowed within 6 months of when it was filed. So I strongly encourage you, if you're in a rush to get a patent or interested in getting one quickly, think about the Track 1 procedure. It's been very effective. And the other thing I'll tell you is that it actually, in my view, it actually saves cost. Even though there's a higher filing fee, what we find is that most of the examiners seem very motivated to actually work with us. They'll actually call us and say, you know, I reviewed the case. Instead of just issuing a rejection like they normally do, they'll say, look, here's the prior art. I think here's some potential differences. If you just kind of clarify your claims a little bit, they're more proactive in coming to us. And if their requests are reasonable, we'll do it. And in some cases, we don't even get a first rejection. We do the amendment and they issue a notice of allowance. We had one company recently that is in, you know, they're doing this at a high level. It's like aggregation on a location basis of social media feeds, and they have apps that do this. We've got them, I think they filed 7 patent applications, and all 7 were allowed within the first 7 months. So it's a very powerful tool if timing is an important issue for you. Yeah, question?
Well, in that example, it sounds like those are very powerful, very general patents, so that this allows anybody feeding any data into it on social accept through their patents. Is that
I did a high-level generalization. You know, each patent, like that, this is one of the problems with patents. People say, oh, I have a patent on you know, Facebook post. You know, when you actually look at the patents and you look at what the actual claims are, right? The claims define the legal scope of protection. You have to kind of get into it. So I wasn't trying to really kind of use it just as an example of more the timing of that as opposed to the subject matter. But yeah, I mean, it still has to be patentable. They're still examining it, and if you know if what you're doing is not different than what others have done, you're not going to get the patent just because you filed Track 1. But if it is different, you're going to get it quicker.
But it sounds like they would be able to prohibit anyone else from doing the feed.
It doesn't just protect feeds, but if it's covered by their patent, they will be able to prevent it.
Yeah, but you're looking at it from their standpoint. From, I mean, everyone else in the world can no longer do a feed with social.
Like I said, it's not that broad. That's the topic that it relates to. Yeah.
So I was curious when you said that you can patent a game mechanic. What I've heard from the Las Vegas gaming world is actually the math models are heavily patented, and a lot of innovation gets stifled in the Las Vegas kind of gaming because, you know, the patent owner just doesn't want to develop it any further. I had not heard anything comparable to that in the video gaming world. Yeah. But is there any kind of a bright line there, or is that just an underexploited area for video game creators, or?
Well, we're seeing more and more patents are issuing in the game space on different game mechanics, and so you know the gaming, the Vegas gaming stuff. There's tons of patents out there, like you know, like kind of the aggregated jackpots over multiple machines, and there's all kinds of patents that IGT and Shufflemaster and all those companies are getting. But on the pure game side, again, there's many mechanics in games that are patented. Like there's an entire class of patents. The patent office, the way they categorize patents is by technology area. And they have what they call classes and subclasses. There's an entire class of patents on games. So I mean, you know, if you want to see, if anyone wants to see examples of you know, kind of game mechanics, you can. I'll send you the list. You can see like broken out by topic and different aspects of game mechanics. You just go to the PTO website and look them up and get examples of what's there. But they're issuing at a faster and more furious pace, and there's more and more litigation in the game space right now too, which is going to cause more companies to file more patents for at least defensive purposes.
So we had Marcus Yoder, who's the executive business development for IGT Digital, come by today, and the math models you're talking about, they're there for a reason, like for compliance reasons. They need to show that you know, this slot machine, this game is fair.
This is
right?
specifically how it works. Yes.
Yeah, so this is, no, it's, they have a compliant, there's a law for compliance that says, you know, this needs to be fair. And so what's that math model? And something like 96.7%, you know, theoretically, could you reach your limit of actually having like, you know, getting your money back or whatnot, right? So to that patent, or those set of patents, I think is more along fairness compliance, rather than mechanics for how a customer would go through an experience, which is, I think, more the patents that around regular gaming that Jim's talking about. So just a different purpose.
But both are patentable, and both, there's on the Vegas, the gaming side, there's just, it's a very, very patent-intensive industry, because there's several, or a limited number of big players, and they're all very protective of their innovations.
On public disclosure side for filing for a patent, we used to be very diligent on NDAs, so you don't publicly disclose what your idea is. VCs don't sign NDAs anymore. So for an entrepreneur, if when you're in a conversation with a VC, if you disclose your idea without being under NDA, is that triggering a public disclosure?
Not necessarily, it's fact specific, but what I suggest is that, you know, you're right, many people, not just VCs, won't file, won't sign an NDA when you have an initial conversation. You get deeper into diligence, they might. What I strongly suggest is that the next best thing is to, if you tell someone, look, this is confidential, I'm going to tell it to you confidential, I don't want you to disclose to anybody, people will normally say, okay, that's fine. They just don't want to sign the agreement. Do that and just send them an email. Thank them for the meeting or the call, whatever, and say, you know, enjoyed such and such, and as we discussed, you know, please keep this confidential. So at least you have some record that it was confidential. Generally, for a public disclosure, it has to be publicly accessible. A one-on-one disclosure, even without that level of kind of a follow-up email, generally is going to be deemed to have an expectation of confidentiality. But get the protection if you can, even through the email, just so you've documented it. Because when it comes to confidential information, a big part of it is how do you treat the information. And so by doing that, you're showing that you tell people it's confidential, you're following up, and you're treating it that way. It's going to go a long way to help you. Now, if you have that conversation with 1,000 people, right, it may become generally known through all these individual disclosures, and so that's why I say it's fact specific. So if it's just one disclosure, you're probably going to be okay. Another question?
Have you seen any defensive publication in the games industry as an alternative to patenting?
Very, very limited. I think defensive publication, you're better off filing a patent or just publishing it, but generally no.
And I would also just remind that there's a patent bar, so 1 year after your game is out or publicly disclosed,
right,
you have 1 year to file your patent.
Right. That's in
the U.S.
In the U.S., right? And so many of the game mechanics and many of the business methods are not patentable outside the U.S. Most countries outside the U.S., for something to even qualify for patent protection, you have to be solving a technical problem. And merely using a computer or software to implement a business method or you know, kind of solving a business problem or providing entertainment in general it's much harder to get those patents outside the U.S. because the scope of patentability of what is protectable is different.
In my experience, patent protection is very limited value in the game business. All the big publishers are going to have hundreds of patents that you'll be violating, and so if they violate one of yours, they can counter by saying you violated 20 of theirs, and it's a standoff, and a lot of letters go back and forth, and that's the end of it. So I haven't read about any significant lawsuit claim settlements on game patents. I've seen them on controllers and the hardware, but never a game software patent. So.
What about experience with creating sellable IP?
Right. So from the standpoint of creating it and then just selling it off to someone else to yeah.
Yes,
So I mean, I can tell you without going, we've worked with a number of big. You'd be surprised. A number of big publishers don't have a lot of patents that they traditionally haven't. They're getting into the game, so to speak, the patent game. So some are filing more aggressively. Like Zynga has 130 something patents. I was just on a panel with Reggie Davis earlier today. He was saying that. But the thing is, the perception that patents have no value is, I think it's a common perception, and in some cases it's right. But I can tell you that the reality of patents is there's an offensive value, a defensive value, and in some cases just kind of a strategic value or some kind of intangible value. From the offensive perspective, if you are getting patents and you want to go out and sue people, yeah, you have to be careful who you sue, because if you sue a big company and they have patents that you're infringing, they're going to countersue, and it may end up being a cross settlement or some other outcome. But from a defensive perspective, the patents can be very valuable. And the other thing is, many of the situations where we've seen patent infringement, it's not necessarily, there are big companies that rip off small companies, but we've also seen companies of comparable size that don't have big portfolios. And so I think it's case by case, right? The point's a fair point, but I'm telling you that if you look at the number of patent infringement lawsuits that are being filed in the game space, it's increasing. And at a minimum, from a defensive perspective, if you have competitors that have patents and you don't, you're at a disadvantage. So again, just to at least have the ability, if you get sued, to have something to countersue, and just even if you want to just kind of do a cross license and settle, it gives you some ammunition to do that. The analysis of whether it's worthwhile to file a patent or not for any company is case by case. If you're more of a content company, patents are not going to be as applicable to what you're doing. If you're more dealing with a platform or some unique functionality or game mechanics, then I would consider how patents fit into your business. We're kind of near. There's a couple other topics we were hoping to cover. We're kind of near the end here. I don't want to keep people late if we don't. But I also want to kind of just throw it out to if there's any other questions or topics we haven't covered that you want to ask questions about.
Are there any patent trolls in the gaming and
yes, there are.
area?
Yes, there's patent trolls everywhere. Every rock you turn over these days is a patent troll. And you've seen companies like GameTech and others that have filed some suits, and there's an increasing amount of activity. And what we're seeing is actually companies that have patents that aren't even game specific, but that apply to general methods of transmitting data over the internet, kind of aspects of that. We're seeing a lot of the people targeting game companies now in that space. The whole patent troll, for those of you who don't know, the patent trolls are people who don't really create the IP. They go out and buy patents from other people and go out and license or sue people. It's challenging, and the reason is that it's hard to create leverage over them in that it's very easy to file a lawsuit even if it's a marginal claim. There's while there are certain protections for claims that are completely frivolous, the courts are very reluctant to impose sanctions or award attorney's fees, and so they'll bring claims and try to seek settlements in many cases that are less than the cost of litigation. And you're faced with a tough business decision: do we pay them, or do we go through and try to invalidate the patent or prove non-infringement and incur $2 million in cost to do it with really no upside? One thing I will tell you is that another part of the patent law that was changed that's different that I think is relevant. If you get sued for patent infringement by one of these trolls, they typically are not just suing one company. They're typically suing largely either the industry or groups of companies that have a certain genre of game. One of the things that can be a very effective tool is that when you get sued for patent infringement, you pretty much have two defenses you can make. The first is either you don't infringe, meaning the patent doesn't cover what you're doing. That's kind of a personal defense, and that's kind of one-off. But if you think the patent's invalid, that's something that's common to everybody. If the patent's invalid, it's invalid for the whole industry. So one of the things that we've done in connection with some of these cases is that we've pooled together resources, and there's more under the new law. There's a greater ability to go back to the patent office and challenge patents that you think are invalid. So if you find prior art that wasn't considered when the patent was initially granted, you can go back to the patent office and they'll re-examine the patent. That can be a lot more cost-effective than doing it through litigation. And particularly if you find a group of companies who are willing to share their resources as far as their knowledge of prior art, and also in many cases share the cost of those proceedings. It can be more cost-effective and can be beneficial for everybody. Yes?
Do you have any advice on how to protect, say, illegal download of games? Like certain websites that host international gamers, they have all these illegal games. I mean, not illegal, but like they have games on their website for illegal downloading.
Yeah.
So what are some of your advice for gaming companies on how to regulate that or prevent that from happening?
So it varies depending on where the companies are located. In some jurisdictions, it's very hard, is the short answer. Again, in the U.S., if the game is copyrighted, you can use the DMCA takedown notice. So if someone creates, so it depends if it's the platform provider that's doing it or someone's copying the game. Right? If someone's copying the games, you can send a notice to the platform provider and say this game is infringing our copyright, and do the DMCA takedown procedure if it's
well,
proper.
non-U.S. so international regulations.
Yeah, so it's the challenge is, again, it depends on country because copyright varies from country to country. It's generally going to be a copyright issue for the most part. Again, if you have patents, that's another issue. But for the most part, you're dealing with copyright in that scenario, and the law differs by country. There are other countries that have procedures similar to the DMCA, but not exactly the same. So I would suggest starting there because that's the most cost-effective way to evade copyright infringement if you can. If not, then you may need to go through a traditional copyright infringement route, which can be expensive. One thing I'll tell you though on copyright that I didn't mention earlier, many people know that you have copyright protection without even filing a registration. Right? From the time you create a game, whether you put a copyright notice on or not, that's not even required in the U.S. You have copyright protection. If you want to sue somebody in the U.S. for copyright infringement, you have to file a registration. And you can do that anytime. But if you file a copyright registration around the time you publish the game or within 3 months, you get a couple of benefits, two of which can be very significant. The first is what's called statutory damages. Generally, in order to, if you can prove copyright infringement, you still have to prove what your damages are. And in many cases, the damages in a copyright case are not that significant, especially if you catch it early on. And so proving what your damages are, how many people would have downloaded the game if they had to pay for it, and those types of issues, can be challenging. And in many cases, the cost of enforcement can be more than what the damages are, which creates a challenge. Do you let this go on longer, which might become a problem, or do you spend more money than you might get back for the enforcement? So under the statutory damages, a judge can actually award an amount of money to deter the infringement as opposed to compensating you for loss. And they can award up to $150,000 per infringement. So you only get statutory damages if you timely file the copyright registration. And the other advantage you get from early copyright registration is you can get attorney's fees, whereas normally if you file a registration after there's infringement, you're not going to get attorney's fees. So many people don't file copyright registrations early on. It's very cheap. It's $35. You can pretty much do it yourself online. There may be some issues you want to check with an attorney, but for the most part, I think companies overlook the benefits of timely copyright protection. Any other questions? Any other comments from panel?
I actually think there's one instructive example. Actually, Chris's, I don't know if you want to share it on the trademark stuff.
Oh,
yeah, so it's about trademarks, not patents.
Sure.
But I thought this was really a really helpful one.
So yeah, the one we actually have two, but the one I mentioned to Sana was a game that we created called Big Little Bang, and there was a similar mark, but we had our trademark issued, Little Big Planet, and it was then acquired by Sony, so they suddenly had very deep pockets, and so we had to rebrand at that point. Before that, the original company name was Podscape, and that was around the time that Apple began taking people to court with the word pod in their name. So we've had that a couple of times.
Yeah, so one piece of advice I'd give you on trademarks is that, and again, this is the legal answer, the business people always want to do it different than what I'm saying, but you'll avoid situations like Chris mentioned if you heed this. Many people want to leverage names that are similar to successful games or apps. How many Vil type marks did we see, right? Can't even count them. From a business perspective, it's obvious why people want to do it. From a legal perspective, it's hard to protect Vil by itself, but the thing with trademarks is when a trademark becomes very famous, the scope of protection varies, right? So if a trademark is not well known, the level of protection can be a little bit weaker, but as it becomes more well known, as the Zynga's Vil series was, the trademark protection becomes stronger. So by intentionally piggybacking on that, you are putting yourself in a situation where even if you have a legal argument, you may have to take on a legal battle and use resources that you don't want to deal with. So think about that as you're finding names, and do you really want to have the potential of kind of launching a game, getting a lawsuit, and having to change the name or rebrand it? I mean, how much momentum do you lose? What's the opportunity cost there, et cetera? So, just again, one of those balancing tests between getting the business benefit versus the legal protection.
And I think from my end, like a closing remark, there are many things that I've done that our lawyers have told us not to do, right? But to some extent, what you have to do as a business person is kind of predict how important is it for whoever could be suing you, like how much is it worth their time and effort, right? So it's a little bit of a prediction. I'm sure, I've gotten pushback from other Pillsbury lawyers, but Jim's okay with it. It's cool like that. But you kind of actually are always doing that as a business, because otherwise you wouldn't be making any money. You wouldn't be taking any risks, and some risks you just end up having to take. And it could be a costly one down the line, or it could not be. You just have to use your own best judgment and know a lot about what's happening with all the companies that are playing with you in the space.
Right. Just to piggyback on that, I mean, I think the key in what Sana said is understand the risk, right? So you can make a business decision. You can knowingly accept risk if you make an informed decision. There's clients that come to us and we're like, look, it's a business decision. Here's the range of options. Here's where you are in that little gray band that I talked about. How likely is it that something might happen to you? Or are you into the black band where it's illegal, and if you get caught, this could be criminal? Like, there's a lot of stuff around virtual currencies. You've seen the enforcements around Bitcoin. We'll talk about that more in one of the later events in the series. But if something is going to put you into the criminal realm, we're going to push back a little bit harder and say you really don't want to do this. And if you do, we want to make sure you pay your legal fees up front, because legal fees from prison.
And Jim is cool like that. There are many lawyers who will say, no, just don't go there. Like, they're very academic about it, right? So I think Jim has more of an understanding of business, having practiced as long as he has. But I like the academic lawyers too, because they tell me all the things that could happen, and then I decide if I want to believe them or not.